So let's talk about former high DOJ official Jeffrey Clark pleading the Fifth more than 100 times in his appearance before the House Select Committee. And then let's take on what happens next. Where do the House Select Committee and the Department of Justice go from here? Because justice matters. Hey all, Glenn Kirshner here. So we just learned that disgraced, treasonous, former high DOJ official Jeffrey Clark pleaded his Fifth Amendment right against self-incrimination more than 100 times in his appearance before the House Select Committee. Here is the CNN reporting. Headline: Former DOJ official Jeffrey Clark pleaded the Fifth Amendment more than 100 times in January 6 committee interview. And that article begins, former Justice Department official Jeffrey Clark made good on his promise and pleaded the Fifth Amendment more than 100 times during his deposition with the House January 6 committee on Wednesday, a source familiar with the interview told CNN. The source said Clark chose to plead the Fifth to most of the questions the committee asked. The former DOJ official was in the interview room with investigators for an hour and 40 minutes, and typical interviews with key witnesses have gone on for 6 or 8 hours. So friends, let's take on two issues today, both related to Jeffrey Clark. First, what are the implications of a witness who pleads his Fifth Amendment right against self-incrimination in front of the House Select Committee? What are the committee's options moving forward? And then the second, what are the implications of the DOJ being in a position to investigate one of its own former high DOJ officials? First, let's take on the Fifth Amendment. I'm a fan. I'm a supporter. I embrace our right against self-incrimination. I don't think the federal government should be able to force, compel, or coerce a confession out of us, or force us to incriminate ourselves. But, all of the first 10 amendments to the Constitution, the Bill of Rights, are basically a list of don'ts, what the federal government can't do to we the people. As I tell my criminal justice students at George Washington University, view the first 10 amendments to the Constitution as a brick wall, a big old brick wall, separating the government from we the people, right? Telling the government what it can't do, right? The First Amendment, don't mess with our free speech rights, or our freedom of the press, or our freedom of religion, or our freedom to peaceably assemble and petition the government for a redress of grievances. The Second Amendment, you can't infringe on our right to bear arms. We can talk about how well that one's working out for us. The Third Amendment doesn't get much discussion these days, but basically the federal government can't turn my house into a Motel 6 and put soldiers up in my house against my will. No quartering of soldiers in our homes. That used to be a problem. Hopefully it doesn't become a problem again in the future. The Fourth Amendment, my personal favorite, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The Fifth Amendment's right against self-incrimination, against double jeopardy, and some others. The Sixth Amendment's right to counsel, right to a speedy trial, right to a public trial, right to a jury trial, right to confront your accuser, right to compel witnesses in your favor. Of course, the Eighth Amendment's prohibition against cruel and unusual punishment and excessive bail. So I may be a nerd, but I get justice goosebumps when I think about the power of those prohibitions, the limitations on what the federal government can do to we the people. So what options are available to the House Select Committee now that Jeffrey Clark has pled the Fifth and refused to testify? Well, generally there are three options, but really only two are in play. The one that's really not in play, the committee could try to bring a legal challenge, go to court, and test Jeffrey Clark's privilege to see if it's legitimate, to see if it's viable. But it is. We've all seen the public reporting where Jeffrey Clark was in a conspiracy with Donald Trump to corrupt and weaponize the Department of Justice and use it, criminally to undermine the election's results and install Donald Trump unconstitutionally for a second term. So you know what? Yeah, Jeffrey Clark absolutely has a Fifth Amendment right against self-incrimination, and he can thereby refuse to testify. So that leaves only two options. One is for the committee to simply accept the invocation of the Fifth and move on to the next witness. But of course, then they are deprived of whatever incriminating information Jeffrey Clark might have about Donald Trump or others. So the final option is they can consider granting Jeffrey Clark immunity. When do prosecutors, I'm going to talk about prosecutors granting immunity, but the principles are similar when Congress is trying to decide whether to grant immunity. When do prosecutors grant immunity? Well, I've been involved in more grants of immunity than I can remember in my former career as a prosecutor. Ordinarily, we'll grant somebody immunity when that person, one, has a right against self-incrimination, and two, has really important information and evidence about the crimes of others, typically about the crimes of bigger criminal fish. And we can't really get our hands on that evidence any other way than granting immunity to the witness. Let me give you an example. Let's assume that there's an Oval Office meeting between Trump and Jeffrey Clark. Only the two of them are involved in the meeting, and Donald Trump says all kinds of incriminating stuff that the House Select Committee would like to get its hands on. They would have to grant Jeffrey Clark immunity and force or compel him to testify about the statements Donald Trump made. Let's change the hypothetical. If there's a third person in that Oval Office meeting who heard Donald Trump make those incriminating statements, well, then we wouldn't need to immunize Jeffrey Clark because we would have another witness to Donald Trump's statements. So basically, the prosecutors will consider immunity when it's the only way they can get their hands on important incriminating information. What's the downside of immunity? Well, there are at least a couple of real concerns when we're granting somebody immunity. The first is that if you grant a witness immunity, you can force the witness to testify. You can compel them to testify because the immunity says nothing you say can be used against you. But you can't force them to tell the truth. So an immunized witness could go into the committee hearing room and tell a whole bunch of lies. Now, you could prosecute the witness for perjury, more precisely for making false statements to Congress, which is a violation of 18 United States Code 1001, but you still can't force the witness to tell the truth. So prosecuting them for lies is one thing because immunity does not give a witness a license to lie. It only stops them from invoking their right against self-incrimination. So it doesn't guarantee that they could force the truth out of Jeffrey Clark. But here's the other downside, and I think it's even more significant than the first one we just discussed. If you grant somebody immunity, in the event the Department of Justice wants to go on to prosecute that person, as they certainly must with Jeffrey Clark for the crimes he committed against our nation, it makes that prosecution more challenging. It makes the prospect of a successful prosecution more challenging. Here's why. We have to look back to Oliver North during the Iran-Contra affair, and we can use that as an example of why granting immunity can be so perilous. So Oliver North was granted immunity by Congress, forced to testify testified about his own crimes and the crimes of others. Thereafter, the Department of Justice indicted him, prosecuted him, convicted him of 3 felony offenses in connection with the Iran-Contra affair, and he was sentenced to prison. On appeal, the appellate court reversed or busted his conviction, in part because they said, you know what? We're not confident that the testimony he was forced to give under a grant of immunity before Congress, we're not confident that some of that didn't seep into the evidence that was then used against him at trial. And so I don't believe Oliver North was ever retried for the crimes he committed after his case was reversed on appeal. So that's a possible downside of granting somebody immunity. It makes a later successful prosecution a little bit more challenging. Okay, and let's finish up by talking a little bit about the concept of conflict of interest. What happens when the Department of Justice is in a position where it's going to have to investigate and potentially prosecute one of its own high officials or a former high DOJ official? Let me start with the conflicts framework generally and then finish up by a quick discussion of special counsel and independent counsel. So regarding conflicts, the Department of Justice has very strict rules about avoiding any conflicts of interest. That means actual conflicts of interest or the appearance of a conflict of interest. Those are slightly different things. Let me use a pretty straightforward hypothetical to try to highlight the difference between an actual conflict and the appearance of conflict. I know this probably feels like a law school class. This is our team justice law school class for the day. So let's assume you have a judge presiding over a trial. And it's not a jury trial, it's a bench trial. The judge will decide the issue of who wins and who loses. And the organization on trial is a company or a corporation. And that corporation is accused of defrauding its shareholders. And it turns out the judge is a shareholder in that company. Obviously, that's an actual conflict of interest because any decision the judge makes will potentially impact the value of the judge's stock in that company. That's an easy call. That's an actual conflict, and the judge would have to recuse him or herself from the case. Let's tweak that hypothetical. The judge, again, is sitting as the finder of fact, a bench trial, not a jury trial. And in that trial, the judge's brother was going to be a potential witness, not a party, not the plaintiff, not the defendant, but it's just going to be a witness with relevant information about the matter being litigated. Now, the judge could very well, fairly and independently assess the credibility of his brother as a witness. So it's not necessarily an actual conflict, but at a minimum, it sure gives the appearance of conflict, because how can a judge be expected to fairly assess the credibility of his own brother as a witness? Just a rough overview of the difference between an actual conflict and the appearance of conflict. Here's the problem. If the Department of Justice investigates, indicts, and prosecutes Jeffrey Clark, which it's certainly better, what will the Department of Justice have to do in that investigation? Interview all kinds of witnesses, Department of Justice employees and officials who know Jeffrey Clark, who worked with Jeffrey Clark when he was with the Department of Justice committing these crimes, right? Maybe people Jeffrey Clark supervised, maybe Jeffrey Clark's contemporaries, maybe Jeffrey Clark's supervisors. So it's basically the Department of Justice investigating what went on in the Department of Justice. That's fraught with peril. And there certainly is at least the appearance of conflict, right? Imagine if a sheriff was investigating his or her own deputy. No matter how fair an investigation the sheriff conducted. If the sheriff concluded my deputy's done nothing wrong and we will seek no charges against our deputy, does that have an appearance problem? Does it feel like the public's confidence in the outcome of the investigation will be high or will be non-existent? So if the Department of Justice investigates Jeffrey Clark for crimes he committed while a high DOJ official, and DOJ declines or fails to prosecute him, will there be an appearance problem there? You bet there will be. Now, what's the remedy? Because it's easy to talk about the problems, less easy to talk about possible remedies. And the remedies are few, quite frankly, because there's not some other organization that can swoop in and investigate the crimes of Department of Justice officials. We do have a special counsel statute, right? Bob Mueller was special counsel, but that really has some shortcomings because a special counsel is still under the control and under the direction of the leadership of the Department of Justice. And one thing we have learned, it's that if you have a corrupt president and a corrupt attorney general, Donald Trump and Bill Barr, then I'm sorry, the Department of Justice cannot be trusted to, fairly and honestly and honorably investigate crimes and dispense justice. We have seen that nightmare before. We've lived it. So the special counsel, Bob Mueller was still under the control of Bill Barr and Rod Rosenstein, and we saw how that turned out. Not well. So the special counsel statute really suffers. It's only half an answer to a big problem. How about independent counsel? Well, that's much better because the independent counsel is taken out from under the leadership of the Department of Justice. It's truly independent. The problem is the independent counsel statute lapsed in 1999 and it was never re-upped. So we don't presently have the ability to have an independent counsel in place to deal with the problem that was spawned by the Trump-Barr tenure. I maintain that a long-term solution is a permanent, standing, independent counsel office that will never be under the control of a future corrupt president and attorney general. That's really the only way to guard against a recurrence of what we just went through under the Trump-Barr term. But we don't have an independent counsel statute available to us now. So special counsel might be the best we can do because it really does seem like any decision that the Department of Justice makes to decline to prosecute the obvious crimes of former DOJ officials will at a minimum have an appearance problem. It will feel like cronyism at best and corruption at worst. And we can't have that given what we've been through. And given where we hope to go to save our democracy, we can't have that. The people have to have confidence in the legitimacy of whatever it is that the Department of Justice does or doesn't do in connection with investigating and holding accountable the command structure of the insurrection. The Donald Trumps, the Jeffrey Clarks, and the others. Because justice matters. Friends, thank you for bearing with me. This was a long video, longer than normal. These are big topics, and I know we're going to be talking about them more in the future. But in the meantime, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.